Maybe. Maybe pardon to mention, my lord, petitioner interim bail ଅଛି. ମୁଁ during vacation mention କରିଥିଲି extension of time. The honorable vacation judge allowed my memo to listing for 18 today, my lord, but not listed because court number 7 not function. I filed this single bench matter, division matter. देखिए कौन देख रहा है after launch assume. See that date of surrender 20 तक ଅଛି. Yes.
Jail criminal appeal. So petitioner is in custody since 16 years. I have filed bail petition from 2017.
Give.
And several times I have mentioned.
All right.
Criminal appeal by 9 years.
Minute mention for interim bail. The appellant's wife is suffering from
No. What is the custody period?
custody since 2015.
2015. It's all right. Yes.
The appellant has been languishing in custody more than 7 years.
Give it. Yes, Mr. Alert. Today that orders matters and other matters are there. And after lunch, your lordship's bench would function. So, subject to your lordship's, should I start today or tomorrow? No. You start today. We will take off. There is a noting, Mr. Sarangi, that phrase admission and orders matter will be taken up fast. Yes, that will see that how many phrase admission and orders matter are there. So better you begin because after lunch it cannot be continued. No, obviously it will continue from tomorrow. All right, I will do that. So yes, so, any phrase admission is there? 9. So only orders matter.
Weekly list for orders. Item number 4.
Six. Yes, Mr. Pass. Vigilance case. Item 4 vigilance. Item number 4 vigilance matter. No, vigilance matter. It's a case where we decided the appeal and criminal appeal was dismissed. It's a case under section 302. And since he was on bail during pendency of the appeal, we directed him to surrender within 4 weeks, and if not, then immediate steps shall be taken for his arrest. And but by the time this appeal was taken up for hearing, he has already been released prematurely by the government. Appropriate government has released him, but that intimation was not given to the court when the matter was taken up. So we decided the appeal in May on merit. So we put some pertinent question on that day when the order was passed on 9/2/2024 as to whether there is availability of any guideline or rules dealing with premature release of the convicts during pendency of the appeal.
Let it tomorrow, my lord.
Ah.
Let it tomorrow. Recall, my lord.
Then the secretary has
Yes,
to
sir.
file an affidavit
Yes,
to
yes,
that
ma'am.
effect, and then state shall obtain specific instruction that while releasing the appellant prematurely, whether any condition was imposed that if the release of the appeal so desires is to be recommitted to the prison or not. And IG Prisons has to file an affidavit to that effect by the next date.
Yes, yes, madam.
You
Recall,
see,
madam.
when a person is sentenced to life imprisonment, there is a provision under 433A that he should not be released prematurely unless he completes 14 years of sentence. And that is the power vested on the appropriate government. So, rider is that you cannot. Now, another thing is that the power of the governor is there under 161 of the Constitution of India. There is no such restriction. That means the governor can exercise even prior to 14 years in a case. Now, here is a case where appropriate government has released him premature. So, when appeal is pending and you are releasing him prematurely, maybe following some guidelines, then what would happen if the result of the appeal so desires, if we dismiss the appeal? So that means if the outcome of the appeal would have no effect and your premature release would have an overriding effect on the orders of the court, then that cannot be permitted, right? So, yes, you have got a right to release prematurely, but it should be brought to your notice while considering that whether any appeal is pending or not. That is prima facie thing. And while releasing prematurely, a condition should be fixed that if the result of the appeal so desires, you are to surrender, you have to take. If does not require, it's all right. If is acquitted, it's all right. But suppose the life imprisonment, or then again, the thing is that if we confirm it, you are taken into custody, then question would come whether thereafter, yes. So here is in this case, what has happened, that appeal is pending and you have released prematurely. A division bench decision is there. That is Justice K.P. Mahapatra and Justice J.M. Mahapatra. That decision I am giving to you, just go through it. It is, this very point was that is Banambar Behera versus State. And it is reported in, you can find it out, Monu /OR /0394/1990. Right? What has been stated therein, that same thing happened, that premature release was made, appeal was pending. So that was raised and the 2 points were formulated by the division bench. So the division bench answered that it should be brought to the notice of the appropriate government that an appeal is pending. And there is a prescribed form when you apply for premature release, there is a prescribed form. They said that this form should also be amended accordingly, and there should be a column that whether the criminal appeal is pending or not. That means it should be made aware to the. In that case, of course, it is stated that when the appeal is pending, the appropriate government should not exercise that power. That was there, but now the law has changed that you can exercise the power, because suppose the appeal is not decided for 30 years. That doesn't mean that you cannot, right? Because that's a once 14 years is completed. So how to reconcile these two things? So the reconciliation is possible only if this rider is fixed. That yes, appeal is pending, brought to your notice. In spite of that, you are, in view of the guidelines frame, you think it proper to extend the benefit of premature release to that person, but you are to fix the rider. That
The conditions should be
if
there.
the condition, if the result of the appeal so desires, then he has to be taken into custody.
Right.
After he is taken into custody,
Again,
you can. That is the thing. So that is how we have this also. You find out the law on this point, and whatever we have asked you, this affidavit, etc.
Well, I recall, madam.
Okay, and the law secretary has filed an affidavit, but he has simply annexed some of the guidelines and stated nothing about this thing. So I hope that you have also received that affidavit which has been filed by the principal secretary law. Have you received it?
Because the file is not come there. That's a matter. Tomorrow.
No, you see, this problem arose in that case in 1991. Now it is coming. So it may come also in future. So you want to give a decision on this point. So that, right? So please, if you have not got, so give your pen drive so that it can be handed over to you. That affidavit has been filed by Principal Secretary to Government Law Department. But you are to that order which you have passed on the last date regarding filing of the affidavits by the IG Prisons, number one, then another affidavit is to be filed. Secretary Law Department has filed.
Two affidavits, my lord. One is Law Department, another is IG Prisons, my lord.
I remember, my lords, there are some appeals where because of these premature release, division bench has disposed of the appeals.
No, that should not. That should not.
Subject to. That has been done, I remember, by my lord then Chief Justice.
Yes, subject
when he was sitting
that
in
is
division.
subject to. Not
see-
dismissed.
you
Not
see-
dismissed in limine. Subject to.
Mr. Panda, one thing is that even if you are released prematurely, suppose the convict says that I will not face the criminal appeal. That situation, he has already been released, but still then that stigma remains or not?
Yes, it will.
Yes, right.
It will go with it.
So,
But can the convict say that he will not press after his appeal has been admitted for years?
no. Question is that it is up to him. If he says admitted, question is, so variety of questions come. Suppose he says that means he says that I will not face the appeal. So that means the conviction remains, the stigma remains, but whether he can be taken into custody once again, because the release has already been done. Now the question is that when we are in session over the matter, that is why it is stated that it should be brought to the notice of the and the appropriate government that appeal is pending, and they ordinarily they should not exercise it. But if the guidelines permits them, then if they releases, then certainly that rider should be fixed. Otherwise, it will be a clash between the executive and the judiciary. You just see it. It cannot, because they cannot supersede when. Otherwise, when we'll pass the order, like in this case, we have dismissed the appeal. We have said that it will be taken into custody. Now, can we say that he will say that we are helpless because we have already released him prematurely, we cannot do anything?
But
That
then-
means
then
they are
again a question will arise: the executive has plenary powers of remission,
Yes.
Unfettered right is there.
and if the executive has plenary powers of remission
Ah.
and has remitted a sentence, my lords,
remitted. We are not. We are they. So, case law also says that during pendency of the appeal, that they can exercise. But at that time, a rider should be fixed. Two things. While releasing, considering premature release, one, it should be brought to the notice that a criminal appeal is pending. Number one. Number two, that rider should be there that if the appeal result so desires, then you are to surrender again, then you can exercise your power. There is no, because by that time there would be no so that can be, otherwise that decision has been given by this division bench, Justice KP Mahapatra and JM Mahapatra. This very point was raised. They say that you cannot just when the appeal is pending, you will, then what would be the outcome of the, if we are will hear the matter, deliver a judgment, dismiss the appeal, and we will say that he is on bail. But can we say that will life sentence is confirmed? But since he has been prematurely released, we are helpless. Can we say that? So that is why how to strike
so
a
at that
balance.
stage, the appellant can say that he doesn't press the appeal. If your lordship says that he
At what stage?
at the stage where he has already been released and the appeal comes up.
That is exactly what
That is
we
exactly
say.
is what is the consequence of a remission prematurely? The consequence of appeal, whether it will die on the basis of a not insisting for further, or what will be the duty of the court to proceed with it, because appeal cannot be dismissed otherwise.
Yes, therefore I say, to my understanding, one appellant cannot say that he doesn't want to press the appeal.
Exactly.
But orders have been passed, I have seen
No,
in such cases.
what has happened. Question is that when this point has arose, we are to adjudicate so
But
that
if the point had arisen earlier and Justice Mahapatras had decided it, then Miller's all these subsequent orders are also.
You see, this particular decision, I was searching, it was not reported in any, only Manu Patra it carries that decision.
These decisions probably are never reported.
No, it's a very important decision. You see that. And this way point was raised, and Mr. Beura was a senior advocate. He was engaged by the court as amicus curiae to address on this point. And it might have taken so many days, and this decision has come. So when this decision has gone, they have stated, the division bench has directed that your form should be amended and it should be brought to the notice of the appropriate authority that the appeal is pending. Otherwise, in that perhaps whether that has been carried out or not, we do not know. So he wants it to be tomorrow. We'll formulate some, if after going through your affidavits, we may formulate all these points and want an answer, and so that we can decide. Because in many cases, it may not be possible for us to decide the appeal within that time limit, as it happened.
Yes, ma'am.
Okay. And you will also have the power to release the pre-match.
With the condition of the.
So what would happen to the appeal? And in case this contingency arises, the appellant may say that I'm not facing the appeal. So and
in a situation, if the appellant simply abandon, if he abandon, he will not insist even to not to insist for the appeal. He will simply abandon. And whether the right given to the appropriate authority is unfettered, irrespective of the appeal, pendency of the appeal.
So, it is into weekly list. Let it be Thursday matter. So
no, you
take time.
Take first of all, you bring those affidavits.
Yes, ma'am.
Then we'll formulate those points and we'll give you time. Okay, we'll give you time to study the matter. There is no problem in that. But because we have already passed an interim order that he is not to be taken into custody because warrant of arrest has been issued. So that order still there. So we'll take up this matter tomorrow. You just see that whether that IG has filed an
Filed or-
affidavit or not, and you also take the affidavit of the
Lord,
principal secretary through your pen drive.
Madam.
Okay. And there is another thing. It is mentioned. Have you got the copy of that order dated
Order thing, acha.
9/2? Is it available with you?
File acha, I'll get it.
One thing, learned counsel for the state shall obtain specific instruction to the effect that while releasing the appellant prematurely, whether any condition was imposed,
Imposed or not.
that is very important. Then there is no
Because
problem.
that's why the IG prisons was filed
Ah.
to file the affidavit on that point, madam.
Mhm.
Because the premature release in the board IG is the
Because you see, when you are releasing prematurely, it is to be with conditions also,
madam.
that you are to behave in this way and that way. That is there. That
Condition
if
must
he flouts the condition, then he can be taken
taken into consideration.
right. That is there in the
Yes, sir.
provision. CRPC itself says. So
And the guidelines
conditions are imposed while that how he is to maintain after being.
Madam.
So one of the condition is whether that if the result of the appeal so desires, he is to be
Madam.
taken into
Understood.
that.
Another part is also may consider also because this appeal is a continuation of trial. Appeal cannot be heard without the accused being in custody, and CRPC only two custodies are there, either a jail custody or a bail custody. Otherwise, the person is not before the court.
No.
That is how the question
When you are
arises.
getting the bail,
He may abandon, he may
Bail
not
is a
come.
custody.
No, Mr.
Now
Sarangi.
that somebody is released,
He-
either
he-
is in jail custody nor is
No. In this case, or many cases, this problem
This aspect is also
because it was not intimated to us. Suppose it would have been intimated to us. Let us say in this case it has not been intimated. We decided the case on merit.
taken back. This cannot be heard unless the accused remains in the custody of the court. It cannot be even heard.
No. Question is that again comes that whether that means what you say that the premature release cannot be made unless during pendency of the appeal. You are going to that point.
Because without the accused being in custody, how an appeal can be
No,
heard?
that is again the Supreme Court say you would have list decision got a I am giving you all those decisions. Say your last decision. Recently, the Honorable Supreme Court has said that this point arose. A appeal was not decided. Premature release was rejected on the ground of this pendency of the appeal. They challenged the matter in the Supreme Court. Honorable Supreme Court, CJI, and the other. They said that no, you go on with the that proceeding. No. That you are to consider the premature release. Appeal is pending. So that means what it indicates that
implementation are two different things. They may say that he deserves to be released, but instead of releasing, they should refer it to this court because the appeal is pending.
No.
So this will be again subject to the orders of this court.
That is exactly what we are saying.
Decide,
that
but they cannot implement.
So premature.
They say we have decided he deserves to be released, but instead of releasing, he should be subjected to the orders of this court when the appeal is pending.
What is the purpose then?
Then
what is the purpose of the authority with the government?
No, that
only a decision. It will remain in paper.
After this adjudication is
So
over.
that means there is no purpose. If this court has still finds the appeal.
Court is not going to reverse that because it's a sentence.
No. Court is not going to touch that.
Yes.
Court will have its own decision on the merit of the appeal.
It goes back.
Suppose it happens that the court, as it happens in this court, suppose the appeal is dismissed.
Yes,
so the authority of the government goes.
Everything goes. If convicted,
yes, that is
only the sentence part remains, and that deals with the sentence, not a part of conviction. So that will be implemented.
Mr. Sarangi, just you think of a situation. Suppose that order is passed in the year 2020, and
on priority basis.
No. Everything you know the pendency of the appeal and the appeal is decided after 7 years on merit. Let us say. So if he has got a favorable order from the appropriate government who has authority to pass, so why he should remain in custody for 7 years? Because the appeal is pending here. So everything has to be seen. So it can be sorted out. it can be sorted out in this way. That is why I say that you examine that whether he can be released, putting that rider that you go on now, and if the appeal is finally decided and it goes against you, you can be again take back into. So
Then
that
again the same situation what my lawyer pointed out. Then again that power is restrained.
Where?
It's an unfettered power with the government.
uh-huh.
Then that is again restrained.
No. After the appeal is disposed of finally,
Yes.
then the government is free. Now there is no such restriction. They can again exercise the power, again consider it again. So that would be a different situation altogether. But here the problem is that it would be a clash between the court order. Court order cannot be implemented. You see that what we passed in this case, we passed that life imprisonment remains, and you are to surrender that, and basing on this, the warrant has been issued by the trial court, but it has come to the notice that he has been granted prematurely. Problem lies there. So how it can be sorted out? So that is to be seen.
Only thing that can be said that this information is go to the authority concerned. Thereafter it's up to him.
No, that is exactly, we have to decide. Let him file an affidavit. Take up,
Let them collect the evidence.
You collect the affidavits and some decisions. My research assistant as such.
This committee, the law secretary is a member.
Yes.
The sessions judge Khurda is also a member.
Yes.
Yes.
And despite their being members, how can they decide when appeals are pending? How can they pass such a
question is that that is exactly our point number one would be that whether the appropriate government can exercise the power of remission or commutation under section 432, 33, 33A during pendency of the criminal appeal or not. That would be the first point.
Yes.
Right. And number two, whether the pendency of the appeal is to be brought to the notice of the appropriate government while considering the premature release or not. Number two. So in this way, we'll formulate the point and we'll hand over to you. You just examine and say that. So tomorrow we'll take on. Yes.
Item 5.
Yes.
The appellant convicted arrived for life with a fine 1,000 under section 302 IPC by learned judge High Court Cutter. And the affair lodged on the date 28/4/2008 by in the informant Arjuna Sahu. He is the deceased father, which reveals that the incident happened.
You have been found guilty under 376, 302. And
only 302 is convicted, Millard.
Please come to the not guilty.
Okay.
Right. So only 302.
Yes, ma'am.
302 life imprisonment.
Yes, ma'am.
So since when you are in custody?
Since 1/5/2008, Millard. 1/5/2008.
During trial, you were there.
During trial, you are not on bail.
No.
And during the pendency of this appeal also, you have not been released
in
on
bail. No.
Trial court record final form cover date of custody.
Thank you. I have taken this.
2-5 he was forwarded, and he was what is the order sheet of the trial court order sheet of the bail goes in 9 bail. No, it's not the trial court order sheet.
My trial court order sheet is there. Yeah. Charges herself absolutely.
Only one witness, Miller. PW4 is the star witness of the prosecution.
We just want to check it that your submission that you have not been released even during pendency of the appeal. That just we want to check it.
This has been rejected on 22nd 10/2009. All along it is rejected.
Right, it is in custody. That means you have already 16 years have been completed.
Yes, Miller.
For the learning or the learning counsel for the petitioner and counsel for the state. The learning counsel for the petitioner submitted that the petitioner is in judicial custody since 2/5/2008, and as such he has already undergone 16 years of substantive sentence. And though the paper book is ready, but the case has not been taken up for hearing. Therefore, the bail application of the petitioner may be favorably considered. Land counsel for the state opposed the prayer for bail. Considering the submission made by the land counsel for the respective parties, the period of detention of the petitioner in judicial custody, we are inclined to release the petitioner on bail allowed.
Item 6.
May I please, Your Lordship? Lordship, the appellant has been convicted in simple imprisonment for life for offense 302 and a pay of fine of 5,000 rupees, Lordship. And the appellant is in custody since 8/9/2009.
Earlier bail application was rejected by
Your Lordship. So as per my instruction, it was rejected in 13/8/2019.
13/8/2019.
In IN number 210 of 2019.
Okay.
Lordship is directed for custody certificate.
Kete was. The custody certificate dated 13/5/20.
This is not it.
Under the behavior of the jail is satisfactory, behavior and attitude of him cordial, maintaining every discipline, so on, so there is no adverse report. 302 case that had the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submit that the petitioner is in judicial custody. Their date is correct. Let us verify it. 9/9/2009. And as such, he has remained in custody for more than 14 years. As for the order dated 6/5/2024, the Land Council for the state has produced the custody certificate dated 13/5/2024, which also indicates that the petitioner is in judicial custody for more than 14 years. The Land Council has also produced the certificate regarding the present conduct and behavior of the petitioner from the Senior Superintendent Circle Jail Chodwa, Katak Chodwa, which indicates that the conduct and behavior of the petitioner inside the jail is satisfactory. His behavior and attitude towards the other co-prisoners as well as staff is cordial. It's maintaining the discipline of jail administration. There is no adverse report against him during the entire period of confinement in prison, and no prison offense has been committed by the petitioner inside the jail during the period of imprisonment. Land Council for the state has also produced the report of the IIC Salapur police station dated 15/5/2024, from which it appears that after verification of the PS case records, nothing adverse was found against the petitioner. After hearing the Land Council for both the parties and taking into account the period of detention of the petitioner in judicial custody and the custody certificate and the reports furnished by the Land Council for the state, we are inclined to release the petitioner on bail.
Item 7.
Item 7. It was last occasion. It was listed before Minor Justice Das, Justice D. Das Court, because he was chairing the committee. For that reason, this matter has come to this court. The endowment matter. It went to the Honorable Chief Justice, and Minor Chief Justice has assigned the matter to this bench.
What is this matter?
With regard to settlement of the land which is in occupation of the civils of Lord Lingaraj Temple. Can you turn to Annexure 2 at page 12? In the year 2010, applications were invited.
This matter was admitted or not admitted?
No, my lord. On the first occasion, it was referred to, my lord.
So, what is your prayer in this application?
Prayer to, earlier I approached the Honorable Court. This Honorable Court directed that to approve the land committee, and I have approached by the Annexure 6 at page 25 to be my application to be considered by the land committee. But so far, it has not been considered in view of the order passed by the Honorable Court.
Just a minute.
If at all, Annexure
come earlier to this court.
Yes, my lord. It is a
WPC number 19328 of 2017, right?
My lord.
that was disposed of on 9th October 2017.
My lord,
And
thereafter,
as for the order of this court,
my lord,
the court directed the land to approach the land committee for your grievances.
my lord,
And accordingly, you
I approached.
then you approached
My lord,
and filed the representation,
at test 25.
which is dated 11th October 2017.
My lord,
And it is addressed to the Principal Secretary Law.
my lord.
You have not got any reply from it.
No.
So, what is the status of that representation?
Let him serve a copy.
Oh, you
My
have,
lord, on the last occasion, I served a copy, but he says that he not give.
We have not out copy.
you just give him a copy. You can take up this matter tomorrow.
My lord, my lord.
Now, what about Annexure 3
Annexure 3
of your application?
Annexure 3 is
That is
presided by the Principal Secretary to government,
a-
and they have directed that to submit a report for consideration of further action. So far, nothing has been done, and it was the then secretary was Manor Justice D.Das.
No, it's all right. These documents were very much considered by this court when it disposed of the
Yes, madam.
earlier
After considering, they directed that to approach the
considering-
land committee.
you were directed to approach the
Land
not
committee.
directed. You said perhaps you withdraw it to approach
Yes,
the
madam. Yes, madam. Yes,
land
madam.
committee.
Yes, madam.
It's not that the court directed.
Yes, madam. Yes, madam.
So
I
you
approached,
have
but till
accepted, so you have to take instruction.
Let him serve.
copy.
copy has not been sent.
Yes, madam. Just now I have given.
All right. Let a copy of the writ petition be served on the Land Council for the state. The petitioner, Kunal Das, has filed this writ petition with a prayer for a direction to the opposite parties take a decision with regard to his application pending before the land committee for settlement of land in his favor within a prescribed time. It is the contention of the Land Council for the petitioner that earlier the petitioner approached this court in WPC number 19328 of 2017 relating to with a prayer for settlement of land in his favor by the Lingaraj Trust Board, Sri Lingaraj Trust Board. And when the matter was taken off on 9th October 2017, the writ petition was withdrawn to approach the land committee for ventilating the grievances. Land Council for the petitioner submitted that after withdrawing the writ petition, the petitioner has approached the Principal Secretary Law, Government of Orissa, Bhubaneswar, with regard to the settlement of land, bracket to plot number 432/2207, Mauja, Rajarani, Bhubaneswar, recorded in the name of Sri Lingaraj Mahaprabhu, Marfat Kunal Das, son of Prahlad Das, on 11th of October 2017. But till date, he has got no response from the authority concerned. Let the Land Council for the state obtain instruction about the status of the representation.
Next week, madam. 1 week after.
So let it be on 1st of put up this matter on 1st of July 2024. The Land Council for the state shall obtain instruction in the meantime.
Oh, blessed Lord.
Your Lordship, a copy may be served for the endowment department, Your Lordships.
Yes, I'll give.
Endowment is opposite party number 2.
Copy of the writ petition may be served on Ms. Naidu, who is appearing for. You are appearing for Chairman Land Committee Lingaraj Mahato.
No, open out
No,
two.
Your Lordship. For the Commissioner of Endowments, OP3A.
Then Assistant Commissioner is also there. So
Three.
Lordship.
three,
Three.
three and four.
Three and-
you are
three and
only
four, three and
appearing.
four.
Lordships.
All right. Who is appearing for opposite party number 3 and the name of Ms. Naidu be reflected in the cause list henceforth. Yes.
Obliged, Your Lordships.
Obliged.
Item 8.
In this case, when live conviction is there, 376 is the offense.
No, he has filed an application that is for change of counsel. That is, he has mentioned that Pramod Kumar Nigam is to be appointed. Do you know him, this Pramod Kumar Nigam alias Nag? Whether he's a counsel practicing here in this court or a trial court counsel? Because mobile number, etc., has not been given. Can you ascertain through this? There must be a directory that
I will
High Court of Bar directory. ତାକୁ ଦେଖନ୍ତୁ ଯଦି ଏମିତି ନାଁ କିଛି ଅଛି ପ୍ରମୋଦ କୁମାର ନିଗମ ଆଲିଆସ ନାଗ ତାଙ୍କୁ ଫୋନ କରି ଟିକେ କୁହନ୍ତୁ କାଲିକି ଆମେ ମ୍ୟାଟରଟାକୁ ନବା ହଁ କାଲି
deposition copy ଗୋଟେ
ହଁ ଡିପୋଜିସନ ଆପଣ ପେନ୍ ଡ୍ରାଇଭରେ ନେଇଯାଆନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ।
Item 9.
My lord. Under the case of live conviction, petitioner is a custody minor since 1/1/2017, more than
judgment
7 years. The husband allegation.
just please. P02 life imprisonment.
My lord.
Yes. So how many years you are in custody?
Custody my lord. 1/1/2017.
1/1/2017.
My lord.
So it is only just 7 years. And whether it was rejected earlier on?
No, my lord. This is a first bail application.
First bail application. Have you supplied the deposition copy
Yes,
to
my
the
lord.
State Council? So, Mr. Das, Mrs. Sahu, you are to argue this matter. You have received the deposition copies.
My lord.
Yes, make your submission.
My lord. My lord, in this case, allegation husband killed the wife.
Yeah.
No independent eyewitness. Not the only eyewitness PW3 Bahu.
PW3
3
is
Bahu.
the daughter-in-law of the
Daughter-in-law of the deceased and accused.
Just. Mandakini Mukhi.
My lord.
As it appears, you have given 3 blows by Tangia. The first blow is on the neck, Second blow is also on the neck. Third blow is on the face. So, who is the doctor who conducted postmortem examination?
PW7, my lord.
PW7. Doctor has noticed one injury, okay. One inside.
That was an extensive one. That the blow was quite extensive on left neck, extending to strong muscles to parallel place. Reproduction.
Blow was very severe, Mr.
My lord, in this case, 302 not made out only 304. Ragaragri Kalikaji, that is the only allegation. Hatat se kar dichi. No intention, nothing.
Say that
Absolutely no
single
intention.
blow would not attract the offense under section 302 IPC in every case. Have you seen the nature of blow? You are attacking
The
doctor
doctor
to a
also
vital
opinion,
part
para
of
2.
the body.
Para 2, the time of death was within 24 hours of my examination. The above injuries were sufficient in the ordinary course of nature.
Yes.
The cause of death of a person and it is homicidal in nature. Only bohu dekhichi. Bohu bhi marithabo bhi kon kithi to.
Bohu bhi marithabo.
No independent witness kehi na.
Independent witness କୋଉଠୁ ଆସିବେ? ଘର ଅଗଣାରେ ଘଟଣା ହଉଛି, ବୋହୁଟି ଅଛି, ଶାଶୁଟି ଅଛି, ଶ୍ୱଶୁର ଆସିଲା, ମାରଲା ତାକୁ।
Now age of the petitioner married 60 ରୁ ଅଧିକା ହେଲାଣି, 61 ବର୍ଷ ହେଲାଣି। Date of occurrence 54 plus ଥିଲା, ଏବେ 60 ରୁ ଅଧିକା।
When you will go there, there is every possibility that you may also take revenge against that lady because you are daughter-in-law. So,
another eyewitness also is there, my PW2.
PW2
glance minor.
Post occurrence.
No. Para 2, my lord. Para 2 on first page on the last line. On the previous night on 13/12/2016, there was also quarrel between my father and mother at the relevant time while I was repairing my drums sitting just in front of our house, and my mother was also busy in repairing drums. My father arrived there holding a tangi and all of a sudden gave 3 to 4 blows with that tangi.
Who is this boy? Acha, he's the son.
PW2, my lord.
He's the son. So not only, Mr. Counsel, there are 2 eyewitnesses. 2 and 3 are the eyewitnesses.
And both are corroborated to each other.
Son and daughter.
So son and daughter-in-law, they would be present there in their house. Who else would be there at that time? If you search for independent witness, everywhere independent witness will not be available. And
another date
one side.
Prepare ଭଲ ହେଇପାରୁନୁ ଆଉ ଗୋଟେ
prepare ଆଉ କଣ କରିବେ? ଏଇ ତ କଥା ଆଉ।
ସାର୍ ଆଣି ଫାଇଲଟା ହଟା ଦେଲେ ତ ମୁଁ ପ୍ରିପେୟାର କରିବି ନା ଜେଲ୍ ଆପିଲ ଥିଲା ଆମ ପାୱାର ଫାଇଲ କରି ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଲିଷ୍ଟ ଏନି ଅଦର ଡେଟ୍ ଫର ଫୁଲ୍ ପ୍ରିପାରେସନ୍
କେବେ କରିବେ କୁହନ୍ତୁ?
next week, after a week, 2 weeks.
Learn counsel for the appellant 6 for an adjournment put of this matter will be commencing from 1st July 2020. Yes.
Item 10.
Yes,
after 10 ଟା ବି ଆମ ନାଁ ଆସିନି
ନାଁଟା ଆସିଛି ନା ଆସିନି?
previous name may be deleted.
Previous ନାଁଟା delete ହେଲେ argument କରିବେ, ନହେଲେ କରିବେନି। ଏଇ ଯୋଉ ଆର ନାଁଟା ଅଛି ଏଟାକୁ delete କରିବା ନା ନାଇଁ ପୁଣି? Item number 9 ରେ ଯୋଉ ଅକ୍ଷୟ କୁମାର ସାହୁଙ୍କ ନାଁ ଅଛି।
ଅକ୍ଷୟ ସାହୁ ପ୍ରେଜେଣ୍ଟ ନାହିଁ,
ନାଇଁ ସେ ନାଁଟା ରହିବ ତ? Item number 10. You have filed power now, acha, in view of which prisoner's petition at flag C, period the prisoner's petition at flag C for engagement of Mr. S.K.Sahoo and his associates, and Mr. Sarangi and his associates have filed Vinama. The Vinama is accepted. The name of the earlier engaged counsel, Mr. Bishwajit Chena, shall not be reflected in the cause list henceforth. Mr. Sadangi seeks for an adjournment put of this matter on 1st July 2020.
Item 11.
For the prisoner, there is a noting in the cause list. It's a disposed of case. A letter has been received from the Commissioner of Endowments. There is a noting. It has been listed from by the officeman.
Mr. Das, where is Miss Naidu? Here the Commissioner of Endowment has written a letter on 7/6/2021. He has sought for the time for only 4 months. That period has long since elapsed. So there is no necessity to pass any order on this if he has already disposed of this appeal. So what is your instruction? Appeal has been disposed of or not?
I don't have any instruction. Let it come tomorrow. I will take instruction.
Miss Naidu को मध्यम कुहतु instruction ए आमे weekly रे रखुचु. Miss Naidu को कुहतु Commissioner of Endowment करो गोटे चिट्ठी आसीची. से appeal dispose of करिया पई time मागुचंती 4 मास. But that letter is dated 7/6/21. It might have been disposed of or ତେଣୁ ହୁଏତ ଦରକାର ନ ପଡିପାରେ extension. ତେଣୁ ସେ ବୁଝି ଦେଇ ହଁ ତ ଏଟା କାଲିକି ଡାକିବେ. You also
I'll do it.
Item 12.
this only application has come for stay of relation of fine. So what happened to the bail? नहीं admit ये देखिलो bail application दा consider हीजी. There is one bail application was filed also. That is 56 of 2020. The list is actually stay of relation of fine. Any order has been passed on IA number 56 of 2020. ताले सेटा कहीं आसिलानी cause list रे. दीटा हाँ? No. अरे जहाँ जी ठीक है right दीटा बच. Okay. So this Nachiketa Mahapatra has been engaged by the she was engaged Nachiketa Mahapatra, Mr. Nachiketam. Okay. Mr. Das, do you know this man, this Nachiketa Mahapatra? He was engaged by the court on 4/8/2020 as the counsel and he is not appearing.
Not coming now. He's not coming to the court.
No,
I can inform him.
The advocate.
I can inform him, but
jail criminal appeal. Okay. See, some list of the how you can engage for the list of sounds. Yes, next matter.
Item 13.
ये जेल क्रिमिनल अपील टे पावर फाइल करथिले सुशांत कुमार दास कहिबे तांकु ना कोन करियो एटार सुशांत कुमार दास पावर फाइल करथिले प्रिजनर्स पिटिशन भी थिला तांकु एंगेज करिया पई बट ही इज नॉट प्रेजेंट सुशांत कुमार दास तांको मोबाइल नंबर देइछन मोबाइल नंबर ता नै जांतु कांटेक्ट करिवे हां कहिबे से यदि कारण जेल क्रिमिनल अपील यदि न आसीबा आ का एंगेज कर दो जेल क्रिमिनल नंबर ता दे देबे अच्छा गांधी की शादी
Item 14.
In lordship, pray for 1 week time.
ये से live conviction
Lordship, 302 live conviction.
and have you supplied the deposition copy to the state council?
No,
So, Mr. You do one thing. You
I will
take
take
the, you want it next week?
Next
or-
week.
Okay. Learn counsel for the appellant 6 for an adjournment. Place this matter will be commencing from 24th of June 2020.
Lordship, obliged.
Item 15.
Yes, Mr. Mahanti. Yes. Please come to the
My lord, the appellant has been convicted under Section 302 IPC
yeah.
and has been sentenced to undergo rigorous imprisonment for life.
Mhm.
My lord, petitioner appellant is the husband, and the allegation is that he has killed his wife by pouring petrol.
Hmm.
And the honorable session judge has relied upon the dying declaration
Hmm.
recorded by the doctor as well as the executive magistrate, my lord,
Hmm.
to convict the appellant.
What is the dying declaration?
Exhibit 13 is one declaration, Exhibit 5 is another declaration.
Exhibit 13 and Exhibit 5. Which has been by the doctor?
Exhibit 13 is by doctor.
Doctor. And magistrate is?
Exhibit 5.
5 by 1.
5 by 1.
What he has stated in that dying declaration? Exhibit 5 रे कौन पूछंदी 13 रे कौन पूछंदी मो घरे थिबा समय दिन प्राय 1टाରୁ 2ଟା घंटा भितर मोर स्वामी सीमांचल पात्र मो देहरे पेट्रोल ढाड़ी निया लगे देला पार्टी करी डाकी पर लोक माने एम्बुलेंस रे आनी मेडिकल को आनी चंती एथि मोर स्वामी सासू ससुर दियर नीलांचल पात्र दायी जी कि आगुरु मध्य एपरी मारिबा को चेष्टा करथिले मु जहा कहली ताहा मोर कामरे लागियो सो दिस इज exhibit 5 then exhibit 13 टा कला
This is in the questionnaire form.
13 अच्छा इटा
My lord, may kindly come to the evidence of PW 13.
just a minute we want to see the document itself exhibit 13 टा काय 9 हाँ इटा तुमर नाम कौन भारती पात्र स्वामी को नाम कौन सुअंश तुमर परिवस्था हैला किपरि गोटाए 22/5/2017 दिन गोटाए बेले घरे थिबा अवस्था मोर स्वामी आसी मो देहरे पेट्रोल ढाड़ी निया लगाई थिले पूर्वरु सबबेले स्वामी सहित सबबेले झगड़ा हुए निया लगाई देवा परे मु चित्कार करियो मोर स्वामी मते छाड़ी पळाइले कि समय परे मोर चित्कार सुनी साही लोक आसी निया लिभाइले तापर सो other persons who has been named in the first one that is not there here but so far as you are concerned that is there, that you are the person who has set fire to. So what is your submission, Mr. Mahanti?
My lord, my submission is that my lord may kindly come to the evidence of PW 13, the magistrate who has recorded the time declaration.
Yeah. What do you want to point out from that evidence?
I want to point out that, my lord, according to the magistrate, the elder sister of the deceased, as well as the landlord of the deceased and the appellant, my lord, were present at the time of recording of the dying declaration, but they have stated negatively, my lord.
Those two persons not supported.
Yes, those two persons have not supported.
But how do you overcome the evidence of this PW 13? Is the executive magistrate why will tell falsehood and why will record false against you? Those two witnesses in whose presence this dying declaration stated to have been recorded, they have been examined in court.
Yes, yes, my lord, they have been examined in the court. One is, my lord, PW2, that is Susmita Patra, the sister of this the deceased, my lord. My lord, her evidence, my lord, may kindly see.
And Ravindra Kumar Panda?
Ravindra Panda is the landlord, my lord, in whose house the deceased along with his...
No, he is examined as PW?
He is, my lord, a PW.
PW 16 is the owner of this pothouse.
PW 16.
PW 16. No.
Page 16 judgment.
No, PW 16. No. Ravindra Kumar Panda.
Ravindra Panda examine ହେଇଛି?
Yes, my lord.
କେତେ ସାକ୍ଷୀ ନମ୍ବର କେତେ? PW 16 ନୁହେଁ ସିଏ?
No, not
owner of the 26. Ravindra Panda, PW 26. He has been declared hostile.
He has been declared hostile.
And PW 2 କିଛି କହୁନି, ମାନେ I got the information that my sister has been admitted to MKCG hospital for treatment, being informed, so I rushed to this one. So I found to have been admitted and informed the matters on myself. Inquest. Okay, his evidence is that. He has also been declared hostile. He has stated earlier about this recording of dying declaration. Stated the IU that so-and-so set fire. It's not a fact that in my presence dying declaration as to this so-and-so recorded. Okay, that part he has not supported. He was declared hostile. So you are in custody since when?
My lord, he was in. He had voluntarily surrendered before the court below, my lord, on 26/5/2017 and was released on bail on 31/8/2019. Thereafter, my lord, since the judgment, he has been behind the bar, that is since 10/1/23.
Released on bail as per the direction of this court or granted by the trial court or what? Then when the judgment was pronounced?
My lord, 10/1/23.
Last order may kindly see 28/8/2023 order.
अच्छा, last order to come.
28/8
28/8 तो किसी लिखा ही नहीं, खाली accepting the prayer for bail, appeal be listed on 17 January 2024. How come? Then my lord, how को order पूछले? ଆଉ ତ ସେମିତି କିଛି order ନାହିଁ. 14/7 ରେ appeal admit ହେଲା, stay realization of fine ଦିଆହେଲା, ତାପରେ 28/8 କୁ ଆସିଲା, ଆଉ ତ କିଛି order ହେଇନି.
I'm sorry. Wrong mention.
So your period, Mr. Mahanti, is just at that time when you are released on bail, you have remained in custody for 2 years and About 3 months, right?
Yes, madam.
And after conviction, you have remained in 1 year and 5 months. So it is 3 years. Total period is 3 years and 8 months.
Yes, madam.
The judgment was on 11th of April 23.
11th of April.
April. Yes.
Inshallah. Not 10-1.
No.
Then it is 1 year. 1 year. 3 years.
Details को मेला अच्छे पेज 20 here mental accused details टा अच्छे थे केवे to release in custody केवे
Judgment of front page रे अच्छी.
नहीं second page में
Second page रे. Simanchal Patra.
मेला
He was not never released on bail. Who said Mr. Mahanti that he was being granted bail? See page 2 of the judgment. Stated that he is in custody since 26/5/2017. The period has also been mentioned there.
Yes.
That 5 years, 10 months. So if we calculate, then it comes to about 7 years you are in custody. More than 7 years.
more than 7 5 6 9 years
And what is the doctor's evidence?
My lord, post the doctor who was
Examined as PW?
was treating the doctor, my lord, he has also recorded a dying declaration.
PW 15.
But the postmortem doctor, my lord, he has stated that she was very serious.
No.
And the burn was around 90 to 95.
Who is that doctor who conducted
25.
PM?
25
PW 25.
Postmortem doctor.
right
90 to 95% burn injuries.
Yes, madam.
When the occurrence took place and when she died,
They died on the very same day, my
or
lord.
same day.
22nd 5 2017 is the date of occurrence.
Hmm.
And around 2:40 on 23rd she has died.
23/5/2017 at about 2:40 a.m.
She has died.
Hmm.
But the occurrence took place on 22/5.
22/5/2017
Same day
around
था
2:30.
22 तारीख रे घटना ला 22 तारीख रे
22 तारीख रात्रे मरची हो.
वो 23 तारीख एक्सपर्ट. So two doctors have stated, one doctor and one executive magistrate have stated about the dying declaration. 7 years custody.
And my lord, one Mamuni Tripathi, she had brought the deceased to the hospital. She has stated that since the time of admission, she had remained senseless and has never regained her sense. That is PW 5.
Those appreciations are to be done at the appropriate stage. We are now on a day, we will not consider all those things in detailed manner because it may have some kind of impact on the final adjudication if we appreciate the evidence on record and say that this witness stated like this. So now you are in custody for 7 years. Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that judgment that you have that the petitioner is in judicial custody since 26/5/2017, and as such, he has remained in custody for more than 7 years. And Since the appeal is of the year 2023, there is no chance of early hearing. Learned counsel further submitted that the case conviction of the petitioner is based on dying declaration, which has been recorded by the doctor by Exhibit 13 and by the executive magistrate by Exhibit 5. The learned counsel argued that even though the executive magistrate PW 13 has stated that when the dying declaration was recorded, the sister of the deceased, E. Sasmita Patra, and one Ravindra Kumar Panda were present, but those two witnesses being examined as PW2 and PW26 respectively have not supported the prosecution case regarding any dying declaration being made by the deceased in the hospital. Land Counsel further submits that the doctor who has conducted postmortem examination, that is PW 25, has stated that the deceased had sustained 90 to 95% of burn injuries, and therefore it is very doubtful about his state of mind at the time of recording of so-called dying declaration. Land Counsel submits that in view of the fact that the co-accused persons who faced trial along with the petitioner have been acquitted by the London trial court, the bail application may be favorably considered. Land Counsel for the state opposed the prayer for bail, placed the evidence of PW 13, PW 25, so also PW 2 and PW 26. Considering the submission made by the Land Counsel for the respective parties, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail allowed.
Item 16.
The appellant is in custody since 10/10/2014 for the commission of offense under section.
Yes, what is the date you said?
10/10/2014.
2014.
For the commission of offense under section 307 and 302 of the Indian Penal Code, and sentenced to RI for life for the offense under section 302 and fine of rupees 2000, and for the offense under section 307 5 years conviction and fine of rupees 1000. The petitioner is the appellant is no nexus with the deceased as well as the injured. It is alleged that while the
What is the name of the deceased?
my lord, name of the deceased is Unna Tirki.
Unna Tirki.
My lord.
And date of occurrence is
9/10/2014. In the
Eyewit-
midnight of 9/10/2014,
eyewitnesses are there.
my lord, there was
injured
alleged
witness also.
eyewitnesses, but there was discrepancy in the statement of the
Just injured eyewitness ki hai?
Injured
PW1,
PW
mother, na?
mother of the deceased.
PW
1.
PW1, mother of the deceased.
Initially, she had stated that he has not seen the
What is the weapon of officer?
lathi.
Lathi. How many blows you have given?
That was not discussed in the trial court judgment.
No, as per the PM report, how many blows are there?
PM report, PW,
With the doctor who conducted PM again.
Conducted PW 18 is the PW 17 is the doctor.
So one injury on the left forearm. Second injury is adjacent to the first one. Third one is a bruise on the left hand. Fourth one is a punctured, lacerated wound on the mid forearm, the right hand. Okay, internal injury, there is contusion of size on the right side chest. Then injury number 2 is individually sufficient to internal injury number 2, that is liver residue injury type. Shock and hemorrhage as a result of which so you assaulted on the chest or what with the that PW1 is the, let us see that
PW1 is the injured mother of the deceased.
Assaulted me by lathi on my forehead, causing bleeding injury. Accused also assaulted my son, who succumbed to injury. Acha.
The first line he has stated that I don't know the accused. First line, my lord. The informant is my daughter. I do not know the accused. And
so, as it appears, you have assaulted the deceased by lathi, and the blows has been given on the hand. One of the blow which was perhaps given on the chest, that caused the internal injury number 2, which was held to be individually sufficient to cause death. No injury on the head. No. You have never been released on bail during trial.
my lord.
A trial court recorded you have.
My lord, in the judgment itself.
Judgment लिखा ही.
My lord.
Second page. हाँ 10 conviction अच्छा. पहले अपन को अगला 9 years.
Nine years, 8 months.
9 years, 8 months. Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 10/10/2014, and as such he has undergone 9 years and 8 months of substantive sentence. It is further submitted that the injured eyewitness PW1 has stated that the petitioner assaulted or as well as the deceased by lathi. And the doctor who conducted postmortem examination, the doctor bracket like on the PW17, who conducted postmortem examination, noticed 4 external injuries on the hand. However, one out of the 3 internal injuries, injury number 2, which caused linear superficial laceration of size 6 cm on the anterior surface of right lobe of liver, has been opined to be individually sufficient to cause death. Land Counsel further submits that the petitioner has good chances of success in the appeal. Balance of convenience is in his favor, and there is no chance of early hearing of the appeal in the near future, and therefore the bail application may be favorably considered. Land Counsel for the state oppose the prayer for bail and place the evidence of PW1, so also PW17. Considering the submission made by the Land Counsel for the respective parties, nature of evidence adduced, postmortem report findings, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 17.
May I please, your lordship? Today I am appearing on behalf of the petitioner.
You are Mr. Vishwajit Tripathi?
Tripathi.
Okay. There is some delay or what?
My lord.
So have you filed any application for condonation of delay?
No, my lord, I have not filed.
So once you have appeared, then you have to file. What is the, how much delay is there?
66 days, my lord, as for noting.
Just a minute. Code लिखा है जी. 66 days. So you file an interim application for condonation of delay. You have got the brief, you have got the judgment with you.
Yes, my lord, I have the judgment, but not the appeal memo.
No, appeal memo, it's a jail criminal appeal, so it's just a prisoner's petition has come, and there is no such appeal memo.
My lord.
It is just one page. So that is how the jail criminal appeals are. If you want, you can give you that prisoner's petition, and you can file also the appeal memo.
Appeal memo you can file.
There is no problem in that. There is no appeal memo as such filed. It's just a prisoner's petition with that judgment it has come. Okay?
My lord.
So, Mr. Biswajit Tripathi and his associate filed power for the appellant, which is taken on record. The stamp reporter has pointed out that there is delay of 66 days in filing this jail criminal appeal. Stop. The Learning Counsel for the appellant seeks some time to file application for condonation of delay. Kebe rakhiba kuhuntu?
July 1st.
July 1st. Put of this matter in the week commencing from 1st July 2024. If any application for condonation of delay is filed, the same shall be placed on record. Copy of the interim application be handed over to the Learning Counsel for the state. Yes.
Oh, please.
Item 18.
May I please, your lordship? The last occasion, my lord, called for the CA of the application.
So prisoner's petition has come.
My lord. Last CA मगायतला
Last occasion, let it be tomorrow, my lord.
And you have filed your Vinama.
My lord, already.
Okay. So that means you are Mr. Deepak
Deepak
Ranjan
Ranjan
Mishra.
Mishra.
So this A. Mishra, K.M. Sahoo and L. Mishra are
Our
your associates. We order for produced custody certificate indicate that custody in 6 years and 5 months. And after pronouncement of the judgment, he has remained for 1 year and 6 months. Custody certificate is a double murder. State Counsel will obtain instruction about the criminal antecedent. What do you say, Mr. Da? Tomorrow. All right, it will be taken up from this weekly list.
Specific kodale asya.
Huh?
Specific na kale asya na list.
Weekly list niya.
It is in the weekly list. So
Complementary.
no, what?
It's continuing.
It is continuing for. Why it will again be listed for in the supplement as well. As for the noting, we cannot take up 19, item number 19, because it is not a phrase admission. Yes?
19, my lord.
No, the noting is that phrase admission and
order.
phrase.
I also want adjournment. I will examine the LCR. LCR has received. Taken up next week, my lord. Yeah, we'll examine the LCR, my lord. LCR has come.
So you collect by way of pen drive, you collect the, that is LCR is available and with either pen drive bill. So Mr. Das, it will be taken up next week. Next, the land counsel for the petition of 6 for an adjournment. And
The Union of India is there. Mr. Bhokta is there.
Mr. Deepti Ranjan Bhokta is present from the for the opposite party. Land counsel for the petitioner submits that the LCR may be in the settlement revision cases may be supplied to him through the pen drive. So let the registry supply the LCR of those settlement revision cases on the pen drive of the petitioner counsel. Yes.
Item 1.
Mr. Das, I think prior to the vacation, 2 death reference cases we have had, and it was adjourned, maybe for some reason. In one case, I think additional evidence
Already taken.
no taken je mane soda kebe date fix
Sir, next week acha.
Acha, next week.
I mean 21 yeah
24.
24.
And another case, I think Mr. Panda was arguing
Yes.
that
It is also on
24.
24. Then it's all right.
24. Can I pray that in particular that cases matter the statement recorded that has been come to the court matter. Can we get that?
You want it?
Man.
Okay then. So in that case, if I remember correctly, that PW1 is the sole eyewitness. So
in two different cases,
on the basis of her statement, the conviction was.
He has stated something else in the another juvenile case matter. That's why
after in that juvenile case, his statement is totally different.
Man.
Then this first case in which death sentence was imposed, that was remanded back. And cross-examination was also, opportunity was given. But the questions which were to be put to that witness relating to the his statement made in that subsequent case, that was not done there. For that reason, the Land and Counsel filed that 311 petition. It was allowed,
Yes.
and
It is remanded.
trial court it was
So
remanded
considered
for that
It
case.
has been recorded.
That has been recorded. So ତାଙ୍କର ସେ ଯୋଉ subsequent statement ଆସିଛି ତାଙ୍କୁ hand over କରିଦେବେ ଇଏରେ pen drive ରେ ଦେଇଦେବେ ହେଲା। ତ ଏଇଟା 24 ତାରିଖରେ ତ ଅଛି ଆଉ ହେଲା। Alright. Yes, Mr. Sarang, you can start it.
Yes. May I please? Incident is
Is
2110.
to be argued by Mr. Katkia. Just. Hmm? ଆପଣଙ୍କର ନାଁ କଣ?
ନବୀନ ଧାରେ।
ନବୀନ ଦେହୁରୀ ଆଚ୍ଛା। And ଇଏ ଆପଣଙ୍କର ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ସେ ବେଲ୍ ରେ ଅଛି?
ଆନେ ଆୟା ଅଛି।
He's inside.
ତାକୁ କଣ ହେଇଥିଲା?
Like
whether he's in he has been released on bail or
no.
Then where is he?
The
Let us come to the operative part of the judgment.
Two 20
Item number
Is there?
Mr. Sarangi, two persons face trial, right?
Yes.
One is Nabin Dehuri, the other is his son, Hemanand Dehuri.
Yes.
So the charges were framed under 302 by 34. And what is the operative part of the judgment?
205 Miller's page.
Page 205.
Sentence part. Third para.
So both of them were found guilty.
Yes.
Under 302.
302. One is life imprisonment, son. The father is the present appellant who is appearing.
We are asking you that where is his son? Hemanand Deuri, whether he has been released on bail. Bail is chikita.
No.
Just can verify. High Court order sitta dekhilu. Bail fail is chikita.
Because it has never been taken up for.
ଆପଣଙ୍କ ପୁଅ କୁଆଡେ ଗଲା?
ଆଜ୍ଞା ଇନା ଜେଲରେ ଅଛି।
କୋଉ ଜେଲରେ?
ସେଇ ଜେଲରେ।
ଏଇ ଜେଲରେ ଅଛି।
ସେଇ ଜେଲରେ?
ହଁ
ସେଇ ଜେଲରେ ଅଛି ତ? Yes, who is accompanying?
ହଁ।
ଆରେ ତାଙ୍କ ପୁଅ ସେ କିଏ ଜେଲର ଅଫିସର? Mr. Officer, where is his son, Hemanand Deuri?
ଜେଲ ଭିତରେ ଅଛି। ନମ୍ବରରେ।
ଆରେ ଜେଲ ଅଛି ତାଙ୍କୁ ସାମ୍ନାକୁ ଅଣାଗଲାନି କଣ ପାଇଁ?
ଡକେଇ ଦଉଛି।
And that death was not just at that life.
Yes, he has been. He's in. So ତାଙ୍କ ପୁଅକୁ ଡକେଇ ଦିଅନ୍ତୁ ହେଲା। ଆଉ ଗୋଟେ କିଛି ଆଡଭୋକେଟ କେହି ପ୍ରେଜେଣ୍ଟ ଅଛନ୍ତି ତାଙ୍କୁ ବୁଝେଇବା ପାଇଁ ହେଇଥିଲା ଜଣେ ଆଡଭୋକେଟଙ୍କୁ ଷ୍ଟେଟ କାଉନସିଲକୁ ପଠେଇବା ପାଇଁ
ଆସିନାହାନ୍ତି।
ସାମ୍ନାରେ ଆସିନାହାନ୍ତି। କୋଉ ଜିଲ୍ଲା ଯାଉଛି କୋଚିଂ ନା
ସମ୍ବଲପୁର district.
ହଉ ତାଙ୍କ ପୁଅଙ୍କୁ ଡାକିକିନି ଆଣନ୍ତୁ ସାମ୍ନାକୁ ଆଣନ୍ତୁ ହେଲା। ସେଇ ଜେଲରେ ଅଛନ୍ତି ତ ତାହେଲେ ଡାକିନି ଆଣନ୍ତୁ ସେ ପ୍ରୋସିଡିଂ ଦେଖିବେ। ଆମେ ଇଏ ତାଙ୍କର କ୍ରିମିନାଲ ଅପିଲ ଆଜି ଆରମ୍ଭ କରୁଛୁ, ଶୁଣାଣି ଆରମ୍ଭ ହଉଛି। ତ ଜଣେ ଆଡଭୋକେଟ ମଧ୍ୟ ଆସିବେ, କାଲିଠୁ ଆସିବେ। ଆଜି ତ ଲଞ୍ଚ ପରେ କୋର୍ଟ ନାହିଁ, ଏଇ ବେଞ୍ଚ ନାହିଁ। ତେଣୁ ଯାହା ବୁଝେଇବା କଥା ଆମର ଏଠି କଣ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ଆଡଭୋକେଟ, ସେ ସବୁ ଜିନିଷ ସେ ଆଡଭୋକେଟ ତାଙ୍କୁ ବୁଝେଇ ଦେବେ ହେଲା। ଆଉ ଯାହା ଆପଣଙ୍କର ମଧ୍ୟ କହିବାର ଅଛି, ଆପଣଙ୍କର ଆଡଭୋକେଟ ଯିଏ ଛିଡା ହେଇଛନ୍ତି ସେ କଥା ମଧ୍ୟ ଯଦି ଚାହାନ୍ତି ମଧ୍ୟ ତାଙ୍କ ସାଙ୍ଗରେ କିଛି ଜଣେଇବା ପାଇଁ ତାଙ୍କୁ ଜଣେଇ ପାରିବେ, କିଛି ଅସୁବିଧା ନାହିଁ ହେଲା। ତ ଆପଣଙ୍କର ବର୍ତ୍ତମାନ କେସ୍ ଶୁଣାଣି ଆରମ୍ଭ ହଉଛି। ମିଷ୍ଟର ଅଫିସର, ୟୁ ଇମିଡିଏଟଲି ask the son of the this gentleman to come and see the proceeding ହେଲା। ତାଙ୍କୁ ଓକେ ଆଣ୍ଡ ସେ କ୍ୟାମେରା ଇଏଟାକୁ ଅଫ୍ କରିଦିଅନ୍ତୁ, ସେମାନେ ତାଙ୍କୁ କହିଦିଅନ୍ତୁ ହେଲା। You start it.
Yes. The incident is 21/10/2020 occurred at 3 p.m. The overall allegations are like this. The informant, deceased persons are the mother, sister, and brother-in-law of the informant. Informant is a lady.
Oh, it's a case of triple murder.
Triple murder.
Just a minute.
Daughter is the eyewitness.
Daughter is the informant. It's the daughter, PW1, she is the informant.
Just.
ସର ତ ପୁଅ ଆସିଲେ ସାର୍।
ଠିକ ଅଛି। ସେ ଦି ଜଣକୁ ସେଠି ଇଏ କରିଦିଅ, ସେମାନେ ବସିକିନି ଦେଖନ୍ତୁ।
Naveen Dehuri to Emananda Dehuri. So, Naveen Dehuri is the death sentence. Emananda is only life imprisonment.
Naveen hala death sentence.
Again.
Emananda hala life imprisonment. Okay, you proceed now.
Allegation is the
Mr. It's a. Can you tell the names of the three deceased?
Yes, that's what I'm saying. Giridhari Sahu.
Giridhari Sahu.
Yes.
Yes. Dui.
Pirobati Behera.
Huh?
Pirobati.
P-I-R-O. Pirobati
Behera.
Behera. Yes.
Sabitri Sahu. Giridhari Sahu and Sabitri Sahu, they are husband and wife.
Okay.
पीरवती बेहरा हला सावित्री साहू को माँ सावित्री साहू और इन्फॉर्मेंट दे आर 2 sisters
सावित्री साहूर माँ होची पीरवती
आज्ञा गिरिधर साहू हला हस्बैंड इन्फॉर्मेंट हला भौणी सावित्री साहू
इन्फॉर्मेंट ना हला कोन
माणिक प्रुसेट
माणिक्य प्रुसेट
माणिक प्रुसेट
पीडब्ल्यू कहते 1
इन्फॉर्मेंट PW1
So, how many eyewitnesses are there?
4.
So, who are the eyewitnesses?
1, 2, 3, 5, 4.
PW
5.
1, 3, 4.
1, 3, not
1, 3, 4.
1, 3, 4,
and 5.
and 5.
1, 3, 4, and 5. Yes.
5 had seen the
3 and
of Giridhari Sahu, and PW 1, 3, and 4. They have seen the murder of
all the three.
Yeah. Only 2 diseases.
Not all the 3
Not
minutes.
the 3. Only 2 diseases plus.
He said that it is a case of triple murder.
Yes.
Triple murder. Plus
2 different places.
One of the body was found in the cultivable land and the 2 in the village.
Yes.
Oh.
So the 2 murder have been seen by.
So,
5 has been.
just a minute. Two murders have been seen by 1, 3, and 4, right?
Yes.
So, who are the 2 murders? That means
Pirovati and Savitri.
अच्छा पीरवती ଆଉ ସାବିତ୍ରୀ ୟାଙ୍କ ମର୍ଡର ବିଷୟରେ 1, 3, 4 ହିଁ କହୁଛନ୍ତି ଆଉ 5 ନମ୍ବରଟା କାହା ମର୍ଡର ବିଷୟରେ କହୁଛି
Giridhari Sahu.
ଗିରିଧାରୀ ସାହୁ
Giridhari.
Okay, what is the date of occurrence?
21/10/2020 3 p.m.
3 p.m. And what is the weapon of offense?
Axe. Budia, there is a local name. Basically axe.
Budia, BUDIA. This, as per the eyewitnesses statement, this axe blow was given by both or
No. So far as the son is concerned, there is no allegation of assault. Second part of assault where the ladies were killed near the house. In that place, the allegation is when this Savitri Sahu was going to help her mother, the son restrained her by pulling her hair, which was found to be a subsequent development. So his involvement is, he was present. Nothing
so
more.
that means
Nothing more.
Whereas
First part he was not there. Second part is present.
Son Hemananda Dehuri is concerned.
Virtually no
the
evidence.
Assault by axe, that is not there. Only that
he was not even holding any weapon.
Okay, just
that is admitted. Even they tried to implicate his mother, but subsequently deleted.
He caught hold of the top of the hair of one of the deceased.
That is found to be a subsequent development.
Savitri.
As Pirovati murder was assaulted when the deceased Savitri was going to help her.
Let us sequence wise ame jodi jiba.
This is the overall allegation.
No, sequence wise re gale prathame kahaku assault he first Giridhari. Then
mother
Pirovati. अच्छा तापरे लास्ट को सावित्री. Okay, now you proceed.
Allegation is overall that they had been to their land, all 3 deceased persons. This Pirovati was not having any son, so the informant and the sister who was killed, they are the only 2 daughters. The brother-in-law of the informant who has been killed, he was staying in the house as a let-up.
These appellants and the deceased persons, are they related to each other?
Neighbors, common wall. and where disputed terms, whatever material is there, that
there was some
his
landed
properties were taken over by some fraudulent means. That is how this person
In any
believed.
case, but the accused had lost the civil suit also.
Yes, yes.
The accused had lost the civil suit.
Yes. But he believed that they have manipulated it and somehow.
Whatever.
Yes.
But the court has granted the decree in favor of them.
Landed properties dispute is there between the two
That I will
That's
answer. That's a
okay.
allegation is subsequently that came to picture that due to this civil dispute, this is husband and wife, they were staying there. The informant with her husband were staying in a different village. On the previous day, she had come to the village to meet his mother. So the informant was not staying there, or her husband. So she, along with her two sons, which are missing, the children are grown up. They are not there in the picture. So she was there. In the first hour, all three of them went to the cultivable land. They came back. Then they had their lunch. At 2:30, again they left.
All three deceased
deceased persons.
Okay.
Not together.
No one.
Not together.
Okay.
Not together.
Oh, yes.
Gidhari went first to the field.
Yes. Please.
No, you said that they went to the field.
No. Yes. One after.
They had not went to the field. They had not gone to the field.
Yes. Yes. Mr. Sarangi, proceed.
Yes.
Please proceed.
So, let prosecution version that Giridhari first started 10 to 15 minutes thereafter.
No, you said that they went to the field,
came back, had lunch. Again at 2:30, Giridhari started first. 10 to 15 minutes later, the other two ladies, they left.
Okay.
Then the informant, along with the two children of the deceased, came out of the house.
The deceased mean which deceased?
Savitri, her sister.
Okay.
Because other lady is the mother of both the person. She came out of the house and found there is a tube well near the house, in between the field and their house, which is visible from their courtyard. What they say? They found suddenly the father accused, Nabin, came with an axe. They were taking water from the tube well before going to the field. Suddenly, the Nabin came with an axe, started assaulting Piravati, the mother. Then the Savitri tried to intervene. She was restrained by the son of the accused,
Hemananda.
And again, Nabin assaulted her by means of same axe. Out of fear, she, along with the children, went inside the house, raised holla. Thereafter, other villagers came. Thereafter, she opened the door, found these two ladies dead. She narrated about the incident. And while assaulting, these accused persons were saying that we have already killed Giridhar. So they went there, found that Giridhar is also dead, lying in the field.
Same field rate.
No, sir, that is why I interfered, Mr. Sarangi.
You
stated that they went to the field. That is why my
I said
brother is under confusion.
No, the ladies stayed back near
while
the tube
they were
well in
preparing
between.
to go to the field. On the way, they took water from the tube well.
Yes.
While taking the water from the tube well, this incident has happened. So they had not gone to the field second time.
No,
so
that's what I'm saying. Why they were collecting water from the tube well?
So they had not gone to the field.
No, only Giridhari had been to the field.
Just a minute, Mr. Sarangi, you gave an impression as if
they were already on the field.
They were already on. So the assault actually
Giridhari was on the field. These two ladies were collecting water in a tube well, which comes in between and visible from the house.
So the assault on the two ladies took place near the tube well.
Tube well.
Okay. Then that was seen by the informant, and after the assault, he came back and shot the door. You said, and then
with the two children who are
with the
PW 3
right,
and 4.
two children. And when he opened, by that time, the other assault had already taken place, but she has not
No,
seen.
because the accused persons were shouting that already we have killed
Right.
Giridhari.
So who has seen that assault?
5, PW 5.
Yes, but that 5 has not seen this assault of
No.
two ladies which
No.
took place near the.
No.
So that is how the. Okay. So that means one assault. That means two persons were assaulted near the well. The one assault took place in the field, right? What is the distance between the two? This
3 kilometers. On the spot map, it is around 3 kilometers.
no. A distance between the well and the.
Yes, that is a 3 kilometers.
Field, 3 kilometers.
3 kilometers. From the spot map.
Okay. So.
Shortcut rasta है जी.
Thereafter, Millard's police was informed. Police came. Other relations, the husband of the informant and other relations who are in question.
That means, Mr. Sadangi, what you have narrated, PW5 might not have implicated the son at all, because the son's role is in near the well.
No,
right?
I will answer.
Okay.
That's why I said son.
Okay, so son's role only near well, about restraining the movement by holding the top of the air. The other
and the evidence indicates, Millards, they are neighbors, the deceased persons and the accused persons. If somebody from their house goes to the field or to the tube well, they have to pass through the house of the informant.
Okay.
Now, none of them said during that time this son accompanied the father. Now, the PW5 doesn't say the son was there in the field with the father. So that is the only way. If the son has joined the father, he was not there with him. If he's in the house, he has to cross the informant house and reach the tube well. That will come later, Millards. Straight from the FIR, Millards.
Let us come
that
to
police,
the FIR.
Police was called. FIR, forensic thing was called.
Please come to the FIR, because
page 18, Millards.
We want to see that, then we'll proceed.
And this is a FIR drafted by one of the relations. Informant has not scribed it.
This is Manik. This is PW1, no?
Yes. And it's a detailed FIR drafted comfortably.
Okay. Lodged on the same day of the
same day. Okay. After it's already prepared. After arrival of the police at 4:20 p.m., it was handed over.
That means police got some information about the
police. Somebody telephoned the police. Who telephoned? It's not there.
Not there.
The IAC was en route to somewhere around 5 kilometers away. So she straight away reached the spot.
Okay.
This FIR was ready, drafted by one of the relations. It was handed over.
Please place the FIR.
ଲେଖି ଜଣାଇବାର କାରଣ ଏହି ଯେ ମୁଁ ମାନେକ ପ୍ରୋସେସ ସ୍ୱାମୀ
right?
Yes. ତାରାପଡ଼ି ଜିଲ୍ଲା ସମ୍ବଲପୁର ଦଶହରା ଉପଲକ୍ଷେ ମୋର ପିତା ଘରକୁ ଗ୍ରାମ ଲପଡା ପୋଷ୍ଟ ସୁଆଂଶୁ ଥାନା ସୁଆଂଶୁ କୁ ଆସିଥିଲି। ଅଦ୍ୟ 21/10/2020 ମସିହା ବୁଧବାର ଦିନ ଦିବା 3 ଘଣ୍ଟା ସମୟରେ ମୋର ଭେଣୋଇ ଶ୍ରୀ ଗିରିଧାରୀ ସାହୁ, ମୋର ମା ପିରବତୀ ବେହେରା.
Giridhari Sahu is one of the deceased, right? So let us name him D1. Okay. Yes, Pita.
ମୋର ମା ପିରବତୀ ବେହେରା.
Okay, D2.
ମୋର ନାନୀ ସାବିତ୍ରୀ ସାହୁ.
D3 is D3, right? Yes.
He is wife of Giridhari. ଧାନ କାଟିବା ପାଇଁ ଜମିକୁ ଗଲେ। କିଛି ସମୟ ପରେ ମୁଁ ଘରୁ ବାହାରି ଆସିଲି। ଦେଖିଲି ନଳକୂଅରେ ମୋ ମା ପାଣି ମାରୁଥିଲେ ଓ ମୋ ନାନୀ ବୋତଲରେ ପାଣି ଭର୍ତ୍ତି କରୁଥିଲେ। ହଠାତ୍ ଏହି ସମୟରେ ମାଙ୍କୁ ତୀରବତୀ ବେହେରାଙ୍କୁ ଅମଲାପଡ଼ା ଗ୍ରାମର ନବୀନ ଦେହୁରୀ ଓ ନବୀନ ଦେହୁରୀଙ୍କ ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆରେ ହାଣିଦେଲେ। ତାଙ୍କର ଚିତ୍କାର ଶୁଣି ଆମ୍ଭ ଦାଣ୍ଡ ବାଟରୁ ଚିତ୍କାର ଆସୁଥିବା ପଟକୁ ଅନାଇ ଦେଖିଲି ଉଭୟେ ନବୀନ ଦେହୁରୀ ଓ ତାଙ୍କ ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ମୋ ବଡ ଭଉଣୀକୁ ଧାରୁଆ ଟାଙ୍ଗିଆରେ ଗୋଡାଇ ଗୋଡାଇ ହାଣିଦେଲେ ଓ କହିଲେ କିରମିରିଆ is the name of this Nabin Deuri because he belonged to a village Kirimiri.
Nabin Deuri means acha
Right.
DC.
So locally he is known as Kirimiria.
Acha, okay. Like is okay. All names. That is appellant.
ଓ କହିଲେ କିରିମିରିଆକୁ ମଧ୍ୟ ବାଟରେ ହାଣି ଦେଇଛୁ।
Kirimiriya is the disease probably.
ନାଇଁ ଆଜ୍ଞା ଏ ଆପେଲାଣ୍ଟ ଯୋଉ
ତାହେଲେ ପଢନ୍ତୁ
କିରିମିରିଆକୁ
ପଢିଲେ ଆଉଥରେ
ସରି କିରିମିରିଆକୁ ବାଟରେ ହାଣି ଦେଇଛୁ। କିରିମିରିଆ is the nickname of ଗିରିଧାରୀ। ସରି
so D1
this is one okay ସେ ଅଲଗା ଗାଁରୁ ଆସିଥିଲା ସେ ଗାଁ ନାଁ ଅନୁସାରେ
ଆଚ୍ଛା ଓକେ
ମଧ୍ୟ ବାଟରେ ହାଣି ଦେଇଛୁ କହି ରାଗରେ ଦୌଡ଼ି ଦୌଡ଼ି ଆସିଲା। ତା ପଛେ ପଛେ ତା ସ୍ତ୍ରୀ ମଧ୍ୟ she is not there in the picture, not charge sheeted or anything. ବୋତଲ ଧରି ଆସୁଥିଲା। ଏହା ଦେଖି ମୁଁ ଭୟରେ ଘର ଭିତରକୁ ଧାଇଁ ଯାଇ କବାଟ ବନ୍ଦ ଦେଇ ଚିତ୍କାର କରିବାରୁ ଗାଁ ଲୋକେ ଦୌଡ଼ି ଆସିଲେ। ତାପରେ ମୁଁ ମଧ୍ୟ ଗାଁ ଦାଣ୍ଡକୁ ଆସିଲି। ପରେ ଗାଁ ଲୋକ ଖୋଜାଖୋଜି କରିବାରୁ ବନ୍ଧର ଉପର ପଟ ବାଡ଼ ପ୍ରାୟ 200 ମିଟର ଦୂରରେ ଚକା ବାଟ ଜମି ଭିତରେ ଗିରିଧାରୀ ସାହୁଙ୍କୁ ଚଲା ବାଟ ଜମି ଭିତରେ ଗିରିଧାରୀ ସାହୁଙ୍କୁ ହାଣି ଦେଇଥିବାର ଦେଖାଗଲା।
ଗିରିଧାରୀ ସାହୁ ଯିଏ କିରମିରିଆ ସେଇ
ଆଜ୍ଞା ମୋର ନାନୀ ଭେଣୋଇର ଏକମାତ୍ର ପୁଅ ସଚିନ ସାହୁ ଓ ଏକମାତ୍ର ଝିଅ ସ୍ୱପ୍ନା ସାହୁ ନାବାଳିକା।
May I interrupt, sir, for a moment? I've got a very sorrowful news because my Lord on this is Pradyumna Manthi. He's no more.
Yes.
Yes, sir.
Okay. Sachin Sahu is PW. He has been examined.
Yes. Sachin Sahu examined.
We'll just finish this FIR and we'll rise.
Yes.
Just finish it.
We'll finish the FIR and
but not the context. It has been mentioned that they are witnesses.
Sachin Sahu is PW3.
अच्छा मुझे just जानिए हो
जाए। एकमात्र झियो स्वप्ना साहू नाबालिक नेक्स्ट पेज में आई बुढ़ी बयस
नहीं स्वप्ना साहू एग्जामिन है
yes PW4
yes PW4 but in the FIR three things
आई बुढ़ी जी एग्जामिन है नहीं
ना
अच्छा okay yes finish it
आई बुढ़ी बयस 60 वर्ष सर एकमात्र गिरिधारी साहू थिले वर्तमान गिरिधारी साहू नाबालिक शिक्षा और चलिबा दायित्व वृद्धांक रक्षणाबेक्षण संबंध में कहीं नथिबारु सरकार तरफ समस्त साहाय्य अत्यंत जरूरी। So first one, the FIR is a detailed one, drafted comfortably. Why I say so? Here there are the wife of the main accused. She has also been named. The son, it's a combined assault. What has been held in the FIR? FIR doesn't say about the children being outside with the informant. PW3 and 4. FIR doesn't say at all that mo sange mo jhiari putra bhi bahar thile. FIR doesn't say about her children who are also there. Because it's a curiosity or anxiety, whatever. If 2 children goes, the other 2 may follow.
ମୋର ନାନୀ ଭେଣେଇ ର ଏକମାତ୍ର ପୁତ୍ର ସଚିନ ସାହୁ
ଓ ଝିଅ
ଏକମାତ୍ର ଝିଅ
ସେଇଟା ଲେଖା ହେଇଛି ଯେ ସେମାନଙ୍କ ଭରଣ ପୋଷଣ ପାଇଁ ସରକାର ସାହାଯ୍ୟ କରନ୍ତୁ ବୁଢୀ ମା ପାଇଁ but they were there on the veranda, came out of the house with the informant and witnessed the occurrence. That is not there. And their statement also, there is some variations. They say ଦ୍ୱାରଟା ଅଳ୍ପ ଖୋଲା ଥିଲା ସେଇଥିରେ ଆମେ ଦେଖିଲୁ.
No, we will go to that
yes
part. Just
but the FIR, 3 things are missing. What my lord pointed out, that they first Giridhari went, then the other 2 went. That part is missing in the FIR. It's all 3 went together. FIR doesn't say that the minor children also accompanied her to the veranda and witnessed the occurrence. FIR doesn't say, FIR rather says additionally that both the accused persons were armed and assaulted combinedly. It's a combination.
No, it's all right, Mr. Sarangi. What you say, it may not be the encyclopedia.
Yes, that's what usually, Millers, it's said, not an encyclopedia. When an FIR is drafted and detailed particulars are not given. Here, this is an FIR. Why I am emphasizing on that term, which was very well prepared, drafted. By the time even police came, it was drafted and kept and handed over. And all the family members were there. Even the husband who was outside, 30 kilometers away, he was called. Then other relatives were called. They became inquest witnesses, all in the family. Only outsider is PW5.
Keep in mind, when the 3 members of his family
disturbed condition,
have been murdered, and he must have been what state of mind?
Yes,
and do you expect that at that point of time
every detailed particular may not be there? I do agree, Millers. That's the basic.
Yes. So,
but when it's not drafted by her, when her husband and other relatives. What discussion? What discussion? Hey.